call IPOP's lawyer, Kanu, ready for negotiations. Welcome to the news and thank you for tuning in to listen. You made a statement some time ago that Nnamdi Kanu would not be tried in any Nigerian court. What do you mean by that? Yes, I did, but let me put it in another way. Even though Kanu was undoubtedly amenable to prosecution or trial based on the charges pending against him from 2015, his subsequent extraordinary rendition from Kenya has changed all that. That is why I commenced the constitutional suit that is now pending before the High Court of Abia State. But because this question is now sub judice, I cannot comment on its merits, but I can give you an excerpt of this case in chief that I adduced in the originating processes I filed in court. My case in chief is this: that it is fundamentally wrong for the Nigerian state to levy a lethal military attack on Nnamdi Kanu at his home in Abia State while he was free on bond and having failed to kill him, to then pursue him to Kenya and abduct him without due to process of law. The abduction, the torture that followed, and unlawful imprisonment in Kenya, plus its consequent expulsion from Kenya to Nigeria, are manifestly unconstitutional and amount to infringement of his fundamental rights. There is an unbroken chain of notorious violation that started in Afaruku, Abia State in late 2017 and culminated in Kenya in June 2021. It is trite that when a state forcibly takes a fugitive suspect from a foreign country to its territory without giving the person the benefit of extradition process, it amounts to an act of extraordinary rendition that without more triggers insurmountable legal barriers to prosecution. Under applicable laws, a rendition fugitive is entitled to a body of remedies known as collectively reparations, which includes restitution, compensation, rehabilitation, satisfaction, and guarantees of non-repetition. One such law provides that restitution should restore the victim to the original situation before the gross violation of international human rights law. Restitution includes restoration of liberty and return to one's place of residence. In many nations, extraordinary rendition has been held by the courts to be a legal barrier to prosecution. I will give one example with the United Kingdom, where the House of Lords held in such a case that where a defendant in a criminal matter had been brought back to the United Kingdom in disregard of available extradition process and in breach of international law and the laws of a state where the defendant had been found, the courts in the United Kingdom should take cognizance of those circumstances and refuse to try the defendant. I know that Kanu's case is unique, novel, and presents matters of first impression, yet it presents a golden opportunity for a Nigerian court to determine whether it is lawful for the Nigerian state to make an extra judicial attempt on his life in 2017 and having failed to then pursue him to Kenya, abduct him, torture him, and rendition him to Nigeria without due process of law, all because he is engaged in self-determination, which is a protected political opinion, but one which the government of the day is seeking to suppress by means of punishment of some sort. If what they did to Kanu is legal, why did they resort to extradition processes of Benin Republic? And why is America equally applying to extradite Abba Kyari instead of simply levying extraordinary rendition on him? That is the crux of the matter. Do you see his non-production in court by the DSS and recent legal appearances as a rendition of a statement or prophecy, as it were? Let me put it this way. Democratic Nigeria has never been a successful treason trial. Since 1960, democratic Nigeria has had many treason trials without any, except for that of Obafemi Awolowo, netting a conviction or even coming close. No other person has ever been convicted of treason or its guardian verities like treasonable felony or sedition throughout all the democratic dispensation in Nigeria. Even when that of Awolowo resulted in conviction, it immediately brought many issues that still dog Nigeria to this day. Plus, Awo's conviction most probably would not have happened had he not overconfidently opted for summary trial when he could have tarried a while. What is more, his trial was later found to have been tainted with profound judicial bias, and in quick time his conviction and sentence were commuted. Most remarkably, his conviction convulsed Nigeria to no end, especially Western Nigeria, and it ultimately contributed to the 1966 coup that directly led to the Civil War and its horrendous aftermath. The lessons from these are not hard to see, and they are first, treason is a regime-specific political offense, so unless the trial is dubiously concluded during the life of the extant regime, it sunsets with the coming of a new regime. Second, treason trial, if pushed too aggressively, can bring more problems than it initially set out to contain. In some climes, it led to overthrow of a very government in power, such as in the case of Jerry Rawlings, who went from being in jail for treason to overthrowing the very government that jailed him. So, Nigeria needs to tread with caution and a keen reference to history as it ramps up on this overly aggressive treason trial of Mazi Nnamdi Kanu. When an alpha patriot like Kanu gets so upset with the system that he begins to seek solution in separation or self-determination, you talk to him. You do not subject him to trials and tribulations. Simple. As Kanu's lawyer, how do you see his ongoing trial? Any hope of him ever getting freed at the end of the day? Before anybody forms an opinion on whether Kanu should have been charged in the first place, not to talk of being actually tried, you need to first understand the position of the law on what he does. A lot of people may not be aware, but the truth is that the enterprise upon which Kanu is engaged and which grounds his prosecution is known as self-determination, which is legal, not criminal, not even unlawful under Nigerian law. One such law at CAPA 9, Laws of Federation of Nigeria, states that all people shall have the unquestionable and inalienable right to self-determination, and that oppressed people shall have the right to free themselves from the bonds of domination by resorting to any means recognized by the international community. One of such means is referendum. So as you can see, when you express an intention to break away from your country, you have done nothing wrong that should warrant your prosecution for treason. Men are known to be stoic, as they would not openly cry or shed tears. In your pursuit of Nnamdi Kanu's case, has there been any time you had cause to cry, even in secret? The truth is, defending the right of Mazi Nnamdi Kanu and IPOB to self-determination is tough in any society or within a regime that believes that espousing self-determination is a criminal offense, or that those you are defending are terrorists. For this reason, I have had two horrendous situations with the authorities where I had also defended myself for merely being a lawyer to Kanu or IPOB. Nnamdi Kanu himself is personally aware of this. Because of the exigencies of the moment, I cannot say any more on this matter than to add that a lot of times it feels like being moroned between a rock and a hard place. A lot of people are talking about finding a political solution to this impasse so that we can move on as a nation. And from what we learned, there are talks going on in that area. If your client is offered amnesty or freedom on the basis that he renounces his political stance, why won't he accept the offer? You will recall that back in early September 2017, Mazi Kanu was in talks with the Southeast governors with the tacit blessings of the federal government. Then all of a sudden, the dialogue was terminated and fight-on dance was brought to bear. It was not Kanu that terminated the dialogue. When someone demands self-determination through referendum, he has shown sufficient consideration to the state such that should warrant some reciprocity that can begin with a dialogue. Kanu has never ruled out dialogue. So what is stopping the authorities? On this note, we have come to the end of the news. We say thank you for tuning in to listen till I come your way next time. Enjoy the rest of your day.